I'm here specially, Your Honor, today, here as Micah Hollis Green's intervener, here to help all parties settle all outstanding claims.
Mr. Hollis Green, I'm not here to listen to a speech from you.
Okay.
I am here to find out, I'm asking you now to explain why you have not reported as required by the release.
May I ask a few questions before?
No, you can answer the question. Why have you not reported? What's your explanation for that?
That's because I had an emergency happen at my place, and my place was robbed last week, and I have been under immense mental anguish and stress trying to deal with it. Therefore, I did miss the probation, the defendant.
No. But when was the application to the question forward? Right, so you reported immediately after release, which was required on July 5th. You were then told to report July 9th. Then you sent to receive correction. You reside at, if I recall, East Pender near Commercial Drive. Is that correct?
Your Honor,
Is that correct? Is that your address? Yes or no?
That is the defendant's address, yes.
You are the defendant.
I am here especially as Micah Hollis Green today.
Right. Okay. So that is about a 3-block walk to that probation office. So why did you not go up and report? Either on the 9th or any day thereafter?
Your Honor, I was unaware of any obligation that the defendant had to attend any probation appointment. I asked as far as the probation report, the officer received documents requesting a valid order that obligated the defendant, to which nothing was provided.
It's not an explanation for not reporting.
Okay, well, I've been under a lot of mental anguish from my house.
You do understand you're about to issue a warrant for your arrest, which means you will be taken into custody, and you will then, as you were told, be kept in custody pending your trial, which may be some months down the road.
Yes.
You do understand that that is what could occur next.
Yes.
Do you want to think about what you're saying to the court and provide a reasonable explanation for why you didn't report over all that period of time? Because you can do that, sir, or the other consequence is going to occur.
Okay.
And all of this nonsense we're talking about,
Yes.
you do understand, has been ruled on by our Court of Appeals and other courts of appeals in this country and determined to be just nonsense. So, do you want to give me an explanation for how it is you didn't manage to walk 4 blocks and report to probation on July 9th? What is it you were doing that was so significant that you couldn't report on Monday, July 9th?
Well, it was last Tuesday that my house was robbed and I was taken...
Last Tuesday?
Right, and so...
That was
it takes
July
a while
3rd?
to figure things out.
Which
I did report directly after.
Which date are you talking about?
That would have been July 3rd, I believe, when my
Your
house was
home?
robbed, yeah.
You're talking about then an event of having to report after your release from the ship on the following Monday. So why is it you couldn't report?
Because I was still dealing with a lot of mental anguish from what
Mental
happened.
anguish?
Yes, Your Honor.
The warrant will go. Take that, please.
Your Honor, before this happens, I have given the court notice here and now that there is a contract for $5 million per day if I am detained against my consent. The Crown has contracted and given
I'll take that. I'll take any
I'm an ally of the Cayuga Nation. 6 nations.
Can you step back, please?
Can I do this to my friend?
Your keys and your... Anything else?
Here, give it to me. Yeah. Okay.
Sir? I'm here doing business as Micah Hollis Green, Your Honor.
Catering and Smith, appearing as agent for the public Those matters are mostly 57 through 60, but Provincial Court also has matters for
He's detained on all matters. And on the substantive matter, the Crown is wanting to fix the new trial date. And with respect to the breach and the failure to appear for race or racial choice.
So you want to schedule a new trial date for the PPT charge?
That's correct. There have been 2 previously scheduled trial dates that Mr. Hallsgreen did not attend at. So this file has previously been set for a 1-day trial on 2 occasions now. Ideally, it's been adjourned. He was detained just last week. It was adjourned for him to consult with counsel.
You don't got any lawyer through you yet?
No.
You have a lawyer yet, sir?
No, sir, I'll be representing myself.
You're charged with possession for the purpose of trafficking 7th of June 2011.
Who's charged, Your Honor?
You are.
Who is you?
Well, it would appear that you are since you're there. All right, we'll bring them in. I'm not going to schedule this over the prosecutors. Why don't we bring them in to set a date?
All right. And may I confirm, I'm not sure where in the process the provincial matter is. It says 61 and 62, 146. Seems a relatively new matter. Has there actually been a provincial order on this?
Yes, on April 11th. Well, I think perhaps he ought to be brought in.
Your Honor, I have a few questions before proceeding.
We're going to bring you in to set a date, or you can consult with a lawyer. Those are your choices. There's 4 informations. You missed 2 trial dates, and I'm not going to play around with you as to who your name, what your name is, and who you are. So we'll going to be an order of attendance, bringing them in tomorrow. You can talk to duty counsel. And we'll try and schedule a date or do something of a positive nature. You're in custody. You've got charges, various charges outstanding that we need to deal with. The most important one, I guess, from your perspective, would be possession for the purpose of trafficking, breach of bail, failure to appear in court, and obstruction of the peace officer. We have 2 prosecutors here this morning, and yesterday we had 2 prosecutors because some of these charges are federal and some are provincial. The obstruction charge is provincial, resisting or obstructing. I take it from what I've been advised that you do not wish to see or speak with duty counsel freely available to talk to people in custody such as yourself, which is your right. I'm not kind of forcing you to do anything. So that leaves then the matter of whether you're pleading guilty or not guilty to these charges. I'm going to assume, because of your attitude in court yesterday, you intend to plead not guilty.
Thank you, Your Honor. With God as my witness,
I don't need God as a witness. I just want to know whether you're pleading guilty or not guilty.
this matter that has already been settled in private, why would I need to make a plea?
Well, you seem to be taking a position, something to do with jurisdiction. I'm not too sure what is filling your mind and what notions you're operating under, but they're incorrect. And I really don't know why it is that I take it you don't accept that you are Micah Hollis Green.
I am here today doing business as Micah Hollis Green, Your
Great.
Honor.
Well, that's what I need to know.
All rights are reserved and never wavered.
That's fine, but nevertheless, we all have a social contract. Whether we agree to be bound by it or not, you are bound by it as well. And I don't care how you describe yourself, but to the courts, you're Michael Hollis Green. You're pleading not guilty and deeming not guilty in all of these charges on your behalf.
Are you attempting to make a plea for the defendant, Your Honor?
I certainly am.
Is it not true that only the defendant can make a plea?
No, the court can register a not guilty plea on your behalf.
So you're attempting to make a plea on my behalf?
I'm making a
behalf of
plea
the defendant?
The plea will be not guilty to all charges.
Okay, so for and on the record, the judge is taking full liability and suretyship for...
No, you and I don't have any contractual relationships. Your mumbo-jumbo about the judge is taking responsibility for, I reject.
What's mumbo-jumbo?
It is, and I'll provide you with legal authority in due course, or some judge will, no doubt. In any event, we're going to schedule this matter for trial.
Why are we proceeding to waste valuable public resources?
You're the ones wasting valuable public time and resources. I will not entertain any further communication on this issue.
Forgive me for my misconduct, Your Honor.
No, I'm not going to. I'm going to just be quiet for a minute. I'm going to stand it down. The judicial case manager will arrange dates. We'll bring you back in, and we'll tell you those dates. Thank you. I'm assuming you're representing yourself.
Your Honor, I'm here as Micah Hollis Green.
Excellent. Okay, well, we'll proceed on that basis.
So you're taking full liability?
No, I'm not taking any liability. You're disputing liability. There you go. We're calling back. Now, Crown can go and get some dates. I'll schedule it. Very well.
Awaiting this hearing, conduct this hearing on 30th of May at 9:50 in Department Number 2.
And federal matters number 4-7 is set for trial June 28th at 9:30. All four trials will start that day in courtroom 4 at 9:30 with the same trial confirmation hearing date of May 30th.
All right, sir, then I'm going to adjourn these matters to the 30th of May for the trial confirmation date.
Your Honor.
And I'm going to adjourn the trials to the 24th of June for provincial matters, obstruction, and June 28th at 9:30 for the federal drug charge.
Your Honor, is the bond that has been tendered to the Crown not enough to pay for this matter?
I'm not going to involve myself in any more discourse with you on this subject.
And a treatment hearing is also being scheduled for May the 2nd, 2013. We set that on back on April the 11th.
May the 2nd, 2015 is the treatment hearing.
1:30.
If Your Honor doesn't believe that this matter has not already been settled, there could be possibly a theft of securities, and I'll have to notify CRA.
Hollis Green, please don't ramble on about this sort of thing. I'm not prepared to listen to it. We also have a hearing on the 2nd of May, at which time the Crown is seeking to street the bail. That means that the $2,500 you or somebody posted on your behalf to get you released from jail. The Crown says, since you didn't show up for your trial, I presume that they're seeking that to Her Majesty. Thank you. See you on that date. Next case. Thank you.
It was a temporary operating permit that wasn't properly displayed. The officer noted a very strong smell of fresh marijuana. That led to a car being searched, incident to arrest, and inside a cooler were found 2 large Ziploc bags containing almost a pound of marijuana. Mr. Hollis Green didn't testify. He was self-represented, but declined to participate in any meaningful way in the court process. I was satisfied that the marijuana was not for personal use. As the staff sergeant, who was called as the expert witness, testified, a user rarely buys more than an ounce at a time. Why? Well, because it costs a lot of money, and as he pointed out, there's a best before date, which amounts to about 90 days stored in a plastic bag before the marijuana strength begins to deteriorate. I did not, however, find that this was a dollar dope operation. The facts of this case bear little resemblance to dollar dope. The car was described as very cluttered. There was clothing strewn, stuffed animals, fast food wrappers. Even the cooler contained a number of items in addition to the drugs. The drugs were packaged in large quantities in just 2 large bags, plus one much smaller one. There was little or no evidence of any intent to repackage the marijuana into saleable amounts. For example, there were only a few other empty plastic bags present. I put no weight on the presence of a cell phone. That's standard in most cars now. I think the most likely scenario is that the accused was transporting the marijuana elsewhere, either to package it himself or deliver it to someone else to perform that task. Having said that, I do know case law emphasizing that being a mere, quote, courier is not a mitigating circumstance, as the courier is still an essential part of the drug trade. I'm mindful of the sentencing principles, deterrence, both general and specific, denunciation, protection of the public, rehabilitation of the offender. I've tried without success to find a sentencing decision with facts similar to the one before me. There's a myriad of cases dealing with possession for the purpose of trafficking marijuana, but all seem to involve either a grow-up or a dollar-dope. There's a wide range of sentences resulting from these offenses. With the former, the grow-up cases, production, it's not uncommon to find a conditional sentence imposed. Even one case I noted where there was some 307 plants with an estimated value of $95,000, something much more significant than the quantities before me. Frankly, a conditional sentence is something that I might have considered in this case were it not for the views and actions of this particular offender. I commented that Mr. Hollister did not participate in any meaningful way in the proceedings. He could be described using a term that was invented, I suppose, by Justice Rook of the Alberta Queen's Bench in the case of Meads versus Meads. He used the term organized pseudo-legal commercial argument litigant. So it's quite a mouthful. I want to emphasize that Mr. Hollister was not disruptive, nor did he take any steps to frustrate the legal process, unlike many of the litigants that fall into this category. And he, as with others that are covered by this description, clearly denies that the court has any jurisdiction or authority over him. And because of that, I can't possibly find it appropriate to allow him to serve his sentence in the community. There'd be no optimism that he could comply with terms of community supervision. In fact, that's already been demonstrated. In addition to finding Mr. Hollis Green guilty of the possession for the purpose of trafficking, I also convicted him of one charge of breach of a recognizance, failing to report as directed, and 2 charges of failing to appear for 2 earlier trial dates set in the same matter. The Crown is seeking a jail sentence of 6 months for the possession for the purpose of trafficking. I think that's far too heavy a disposition for these facts in this particular offender. I know little about you, Mr. Hollis Green, again because of your non-participation in the process. All I do know is your age and the fact that you don't have any prior record. But when I take all of the circumstances into effect, I'm going to impose a custodial sentence of 50 days for the possession for the purpose of trafficking. Follow that with probation for a period of a year. The only terms of the probation order will be the standard clause that you keep the peace and be good behavior, and you cannot possess or consume any drugs listed in the Controlled Drugs and Substances Act, unless such drug has been prescribed for you by a medical doctor. The other part of the sentence will be the mandatory 10-year prohibition from possessing any firearm, prohibited weapon, or other article set out in Section 109 of the Criminal Code. I do generally agree with Crown submissions regarding custodial sentences for the breach and the failing to appear. So I'm imposing a sentence of 7 days in custody for the breach of recognizance, 9 days for the first failing to appear, 14 days for the second failing to appear. Now, the accused has now spent 80 days in custody, giving him credit for the time served. There's no further custodial sentence to serve, and he's free to go.
Your Honor, thank you very much. Just for on the record, I wish to say one thing. I accept your offer of time served. I will be charging $1 million in fine silver dollars per day I have been detained in custody, and we have a binding agreement on that matter.
All right, well, I'm retiring, Mr. Hollis Green, so it won't be me dealing with your $1 million claim, but I'm sure one of my colleagues will be happy to do it. I'll stand down then while I trade places with another judge. Thank you.
All right.